certain papers which are without any authentication. Copies of some invoices and other things they have filed directly before the court. And then they have made an application that those records has to be taken on record. Then the impugned order has been passed on 24/6/2024 at page 26. That order is under challenge. The order passed on 24/6/2024 at page 26. That is the impugned order.
What's your ground?
There is no provision of law. Even in the application, there is no provision of law. And also in the impugned order, also the learned magistrate has not mentioned on which provision he has permitted the prosecution to take the record documents on record after lapse of 5 years. And added to that, the documents are not authenticated. All the documents are copies.
That's all.
That's
Mere marking of a document will not amount to its proof. Authenticated alla amele.
They are not marking agilla.
That will.
Still they have produced it.
Innu production alli ide. Even
produced
marking will not amount to its proof. Yes.
Marking illa.
Yes,
no
sir.
authentication regarding those documents.
Yes.
My lords, with permission, grateful, my lords. My lord, this petition, I would just try to show the preliminary objection that I've raised. Your lordships have gone through. My lords, he's filed the stay application, which is dated 19th of July. Petition is filed on 19th of July without any supporting affidavit of the petitioner. Now, along with the stay application, my lords may have page the affidavit, which is sworn on 18th of July, when the petition was not even in existence. And he says in para 1, 2, and 10 onwards that this petition has been filed by me and so on 18th of July, when the petition is not even there before the oath commissioner or the lawyer brother who's identifying him. That's my first. It's antedated, my lords, not a proper petition. Subject to your lordship's convenience means that is for your lordship's prerogative to take into account. Now, the only question that arises for consideration is, my lords, the impression which has been given by my learned friend in the petition is as if the petition has been, means this application has been filed after 5 years. No. My lord, the FIR was registered on 18th of May 2016 pursuant to the complaint filed by respondent number 2 as the then general manager of the complainant company for misappropriation and fraud and cheating committed by petitioner along with another co-accused. My lords, we are a company, we manufacture garments for children. And when the stitching is made, my lords, there are certain pieces, big pieces, small pieces, which are called chindis, which are also sold in the market, which is a sellable commodity. This person being an administrative in charge of the things, my lords, committed a fraud by, we had a specific price for white chindis, and for color chindis, it was a different price. He sold this price, these things to private people and misappropriated amount and did not inform the company.
So chindi sale.
For the chindi sales. But the chindi sales, my lords, when the stock was taken into consideration, my lords, it went around to about 60 lakhs for the complete year and all those things. We have different units, my lord, we employ various people and all this. Now, when this FIR was registered, my lords, initially, and since the chartered accountant and the CFO were examining certain documents, he destroyed certain documents, created registers and all those things. And those were certain things were recovered at the instance. He was arrested on 9th June. My lords, I placed the first order. I placed all the orders with my statement of objection, my lords. 9th June, he was remanded to police judicial custody with co-accused till 23rd June. On 14th of June, my lords, may just have my statement of objection.
No, now it is with regard to the marking of or production of documents.
No, we have.
That's all. Whether there is a provision in law to produce or not, and what is the prejudice that would cause to him by marking.
No, my lords,
that's all is the issue.
My lords, I am squarely covered by CBI versus RS by Supreme Court, and 4 judgments of this honorable court following RS by. My lords. That's all.
That's all. Kam khatam.
That's all.
Yes.
Where are the judgments? My set. Would your lordship straight away come to page 37? My lords, this is the first judgment taking care of everything, 173, 175, everything.
37.
Yes, my lords. RS5 versus CBI versus RS5.
Hmm.
And Wallards, would your lordship straight away come to para 7? After quoting 173 and 175, 173.5 and 173.8,
Hmm.
my lords, from the aforesaid subsection, it is apparent that normally the investigating officer is required to produce all the relevant documents at the time of submitting of the charge sheet. At the same time, there is no specific prohibition. It cannot be held that additional documents cannot be produced subsequently. If some mistake is committed in not producing the relevant documents at the time of submitting of the report or the charge sheet, it is always open to the investigating officer to produce the same with the permission of the court. My lord, and that is why the learned prosecutor filed an application for permission of the court. In our view, considering the preliminary stage of the prosecution and the context in which the police officer is required to forward to the magistrate all the documents and all relevant extract thereof, on which the prosecution proposes to rely, the word shall used in subsection 5 cannot be interpreted as mandatory, but as directly. Normally, documents gathered during the investigation upon which the prosecution wants to rely are required to be forwarded to the magistrate. But if there is some omission, it would not mean that the remaining documents cannot be produced subsequently. Analogous provision to section so-and-so, my lords, Supreme Court earlier judgment, it was held that the word shall in 207 capital A is not mandatory, but only directly. Further, the scheme of the charge sheet is further the scheme of the subsection 173 also makes it abundantly clear that even after the charge sheet is submitted, further investigation is, if called for, is not precluded. If further investigation is not precluded, then there is no question of not permitting the prosecution to produce the additional documents which were gathered prior to or subsequent to the investigation. In such cases, there cannot be any prejudice to the accused.
Yes, sir. Anything else?
And my lords, the next
Alright.
page, sorry.
This decision says that 173.8 empowers the investigating officer to collect the documents and to produce before the court by seeking the permission. Here, that has not been done. Directly, the prosecutor has filed several documents that is also not authenticated, attested.
At prejudice, sir.
If attested documents have been produced, I can understand, I can take a defense. in the
Marking
chance
will
of-
always be in accordance with law, production will be in accordance with law, even otherwise 207 is always there.
And
Correct.
lords, his query is covered by page 73, Lordship's judgments of in Vinayak Shetty versus State of Karnataka by this honorable court.
My only apprehension is
SLP
that-
dismiss against that order at page 84.
my only apprehension is authenticated document.
10, 14 and 15 of that judgment.
That's all.
Authenticated document.
Vinayak
That-
Shetty
with that
is clear.
observation-
That was also filed by the learned prosecutor.
With that,
Anything- Anything else?
with that observation, if the documents are authenticated, only
No observations.
ilde idre, what happened? All the Xerox copies which have been produced before the
The court will consider, sir.
We'll consider.
magistrate.
Court will consider everything.
Xerox copies.
Court will consider whether they are permissible to be marked or not and then do it. Yes. Yes.
At least
My lords, I'm
the
mindful.
permissible documents can be looked into.
My lords, we have the original when we come in the witness box.
That
That is
is
what
right.
it is in my possession. My lords, I will
Sir,
not
they
be.
will do it. Why are you
Put in
worried? It
accordance
is
with
his
law.
burden to prove those documents. Mere production or marking will not amount to its proof. Why are you reclosing the issue? Yes. Anything else?
Aಷ್ಟೇ.
ಅಷ್ಟೇ ಅಲ್ಲ? Order
And my lords, I
order
just
ಮಾಡ್ಲಾ
want-
withdraw ಮಾಡ್ತೀರಾ?
My lord, I just
No.
wanted.
Order ಮಾಡ್ಲಾ withdraw ಮಾಡ್ತೀರಾ?
Order ಮಾಡಿ.
ಆಯ್ತು.
My lord, I just wanted to
Hmm.
point out the order passed by the learned magistrate as per the case state, where the information on the website is 25th of June and not 24th of June.
Solid.
Oh, no, I just thought, means that's my duty to point
We'll
out.
leave all the trivialities
No, no,
aside
I've
and
given
decide
the-
the main issue.
My lords, I have given the printout of the
No problem.
the case
Yes.
status report. Much obliged.
The petitioners are before this court, petitioner
Petitioner.
is before this court, calling in question an order. Anything else, Jagdish?
That 173.8.
Permits, sir.
That's
Yes.
it.
The petitioner is before this court calling in question an order dated 24/6/2024 by which the concerned court permits production of documents at the hands of the prosecution. The prosecution heard so and so. The petitioner is the accused. The second respondent, the
And-
complainant,
Advocate.
the general manager of the First Steps Babywear Private Limited, a company which is into production of clothing,
Children garments.
Production of garments for children. A crime comes to be registered on 19/5/2016 against the petitioner for offense punishable under section 406 and 420 of the IPC. The crux of the allegation is that the petitioner has sold unauthorizedly certain chindi nadu.
Chindi.
Certain chindi clothing that is left out after the cutting. Chindi lyak vyavara ಮಾಡಕ್ ಹೋದ್ರೆ ನೀವು.
Small pieces, my lords.
Chindi vyavara.
ಅದು ಎರಡು ತರ ಚಿಂದಿ ಇತ್ತು,
ಆ,
ಕಲರ್ ಚಿಂದಿ, ವೈಟ್ ಚಿಂದಿ ಅಂತ.
ಗೊತ್ತಾಯ್ತು.
ಕಲರ್ ವೈಟ್ ಕಲರ್
ಎರಡು ಚಿಂದಿನೂ ಸೇರಿಸಿ ಚಿಂದಿ ಬಿಡ.
ಅಲ್ಲ, ಕಲರ್ ಚಿಂದಿಗೆ ಇಂಡಿಯಾ ತಕೊಂಡು ವೈಟ್ ಚಿಂದಿ ಸಪ್ಲೈ ಮಾಡಿದ್ರೆ ಅಂತ ಅವ್ರ ಅಲಿಗೇಷನ್.
ಆಯ್ತು, ಆ ಚಿಂದಿನೆಲ್ಲ ಅಲ್ಲಿ ನೋಡ್ಕೊಡಿ. ಎಸ್, ಏನ್ ಹೇಳಿ. So then chindi that is cut from the fabric and leftover of different colors is said to have been sold by the petitioner unauthorizedly and misappropriated the said amount. This is the broad allegation against the petitioner. The quantum of sale is also indicated in the complaint. Based upon the investigation, the police file a charge sheet against the petitioner in CC 1429 of 2017 for the aforequoted offences. Later, on further investigation, a supplementary charge sheet also comes to be filed, adding offences punishable under section 120B, 408, 477A, 201 and 34 of the IPC. The issue in the list does not relate to the merit of the claim of the petitioner, merit of the claim of the complainant or the defense of the petitioner. Before the concerned court, after the trial, of the commencement of the trial, the prosecution files an application seeking to produce certain documents. The production of documents is objected to by the petitioner, the accused, and notwithstanding the same, the concerned court passes the order by allowing the application filed by the prosecution seeking production of documents and permits production of such documents. The learned counsel for the petitioner submits that there is no provision in law to produce those documents, and therefore it becomes an order that is illegal. The submission is refuted by the learned counsel for the respondent. The learned counsel for the respondent. I have given my bandidina. Refuted by the respondent. Therefore, the issue now revolves around whether the documents should be documents being permitted to be produced before the concerned court at this stage is tenable in law or otherwise. The issue need not detain this court for long or delve deep into the matter. The coordinate benches of this court, as well, following the judgment of the apex court in the case of RS Pi, have considered this issue. Quoting all would only lead to the bulk of this judgment. Quoting one is appropriate. The coordinate bench in Vinayak Shetty, 2014 SEC Online Karnataka 12586 has held as follows: para 8 and 10, 14 and 15. All the submissions that are now projected by the petitioner is considered by the coordinate bench in the aforesaid judgment. The
SLP was dismissed.
That's all right. Aforesaid judgment. The said judgment was tossed before the apex court by the petitioner therein, which petitioner therein in SLP 6783 of 2014, which also comes to be dismissed. In that light, deeper delving into the matter as observed here and above would not be required. Even otherwise, section 173(8), which permits further investigation, even otherwise, it can hardly be said that when law permits further investigation, that further documents cannot be marked. The marking of cannot be produced. The production of documents undoubtedly would not amount to its proof. Nonetheless, the producer of the documents has the burden of proving the documents that are produced to be in his favor or otherwise. Therefore, finding no merit in the petition stands rejected.
Can we have the order document the matter listed on 16th? My lords, the matter is listed before the learned trial court on the 16th of December. If lordship can give order dusty subject, or I'll apply post certified copy. No, because this trial court is.
We'll upload. 16 December is too far.
Okay, I'm much of that.
Yes.
Deeply of it. Thank you.
Yes, we can.
Offense under 354, 323, 324.
Steps. ಅದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇತ್ತು, ಇದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಲ್ಲ.
We should process.
Learned counsel submits needful has been done of his to